First-time guest here. We're joined by David Feher. He is a partner and co-chair of sports practice at Winston and Strawn, a New York-based law firm. And David was extremely involved alongside Jeffrey Kessler with the recent Supreme Court ruling at 9-0 in favor of the Alston side of the case in Alston versus NCAA. David, we've talked a lot about this over the last few days and have tried to make sense of it, but would love for you, if you don't mind, kind of in layman's terms, to talk to us about what this ruling means. And thanks for some of your time as well.
No, that's all right. I'm glad to be here. I don't want to get too complicated, but I'll just start at the very beginning and say that there are a really important set of laws that this country has, the antitrust laws. And what it basically means is that competitors can't get together and fix prices, because if competitors do that, they're going to raise prices on consumers. Everyone's going to be hurt. Nobody's going to innovate. They'll just sit back and be fat and happy on their monopoly profits. And that's been a law that's been around for more than 100 years, and the Supreme Court has called it the Charter of Economic Liberty. So if you care about your ability to act in a market without people ganging up and fix prices and putting other people out of business, then you should care about the antitrust laws. Now, it applies not just when you're selling things, but when you're also working. And so you can't have people get together to fix the price of labor, because it'll do the same thing. It'll hold the price of labor down, and you'll be, you'll be subject to getting less than you should have in a competitive market. What this decision did, it was focused on one issue, which is the NCAA got together with the conferences and they passed rules that restricted the ability of schools and individual conferences to compete with each other in how much educational opportunity they would give to their student athletes in D1, in basketball and FBS football and the women's D1 basketball too. I just want to repeat that. I mean, what this is about the NCAA and the conferences restricting educational opportunities of students. And to me, that says it all, because if anything, what the NCAA should be about is an educational mission. And it should be about expanding educational opportunities to the students who are athletes. And so whenever you're talking about, what's this about? What it's really about is, I hate to say this, but the NCAA over the years, it's like anyone, when you give them power that they can exercise pretty much absolutely, they're going to exercise that power to benefit themselves. And the NCAA has been able over the years to have a rigged market where the highest paid employees in states, in so many states around this country, aren't people who you would say, absolutely, this is great, but it's football coaches, but also, sports administrators. For some of them, for the life of me, you can't figure out what they're doing, but they're making $1 million salaries. You have strength coaches in programs who are making $900,000 or more. And the reason is because the market got totally distorted, and it's benefiting the people at the top. The market was rigged against the athletes who were, putting their bodies on the line on the field and on the court, and not letting the market operate at all on the educational side. Let's leave, all the other stuff aside, but even on the educational side, it wasn't allowed to operate. So instead, where does that money go? It's been going to the administrators and the coaches, because since you can't compete against each other to give better scholarships or internships or vocational school studies or other kind of educational grants to the kids to compete, instead that money is going to the administrators and the coaches because the market is totally distorted. There was incredibly strong evidence presented at the trial. The judge issued a very, very strong opinion that laid it out. It went up on appeal. And to me, what's most important in some ways is the sunlight of the decision that was issued by the Supreme Court. Because I think anyone who reads the facts that Justice Gorsuch reviewed in his unanimous decision, there wasn't any difference of opinion on this, but if you just read the facts in that opinion, honestly, you might get a little sick, because it shows how the NCAA over the years has profited itself and profited its administrators to the harm of everyone else. And I know people say, oh, isn't it great in terms of the, scholarships that these athletes get? That's a whole nother debate, but too often the coaches, because they don't want to lose their jobs, they're telling their athletes, maintain eligibility. And that's all they want their kids to do.
And it's not as much about educational pursuits. So
yeah, you have athletes who want to go to medical school, and the coach says no.
Yeah,
you can't.
We
can't do pre-med.
Need to focus on university studies. So let me ask you this: the NCAA, in its statement after the unanimous decision was handed down, immediately referred to it as a very narrow ruling. They wanted to point out that this was educational opportunities only. But I feel like that kind of flies in the face of the concurring opinion that came from Justice Kavanaugh, which I thought was as strongly worded as anything I've seen. I'm certainly not a legal scholar, but I thought the language in that from him was pretty directed. Does this open the door, in your mind, for more opportunities going forward because of what the court said and the overarching opinion, but also in the concurring opinion?
I think you could tell from Justice Kavanaugh's opinion that he was disgusted with the current state of the world, with the NCAA. And just by laying out the facts, because it's completely against any notion of freedom, any notion of a free market, it's people getting together to rig prices and to cause a lot of harm. And the unanimous opinion, okay, it wasn't a narrow opinion that gave the NCAA license to do anything. What it did, if you read it, it basically says, well, there are all these other issues, but they're not before us right now, so we're not addressing them. Okay?
That's fair.
Which is totally different from saying that it's okay.
Yeah.
And the thing I want to say again and again and again, anyone who listens to the NCAA and believes what they say, I got to tell you, if you were at a casino, you'd lose every penny. Because the NCAA, time and time again, has just been so wrong in terms of how they've restricted things to benefit themselves. If you go back to 1984, the last time the NCAA was in a big case before the Supreme Court,
that changed the landscape of college football.
They rigged the TV market so that no one hardly could watch TV games. They claimed it was better.
Georgia and Oklahoma leading the way there.
Yeah, and then after that decision, what ended up happening? TV ended up exploding and being available so that you could watch your favorite team much, much more often. It increased the popularity of the game. So the NCAA was wrong. They've had other cases when they've exercised their power. What did they do in terms of coaches' salaries? Did they do anything where they tried to restrain coaches' salaries at the top? No. They tried to restrict salaries of coaches at the very, very bottom, who were making the least, who had the least leverage. I mean, whenever you give anyone power to really benefit themselves, you can't, and it's not that people are evil, okay, in an intentional sense, but when you give them an opportunity to benefit themselves, how are they going to say no? You're never going to admit it. You're never going to, say, yes, I'm doing this because I want to preserve my monopoly. Monopolists don't do that, okay? It doesn't happen that way.
Yeah, isn't there an old saying about absolute power corrupting absolutely? I think I've heard that somewhere along the way.
Oh, absolutely. And by the way, in terms of this, they're running to Congress, and they're using a lot of pretty words, saying that, well, they want to benefit students now with new name, image, and likeness, rules, which, by the way, they were not willing to grant a penny to anyone on that before until they were forced to.
Yeah.
But now you have
Very
to look
reactionary.
at fine print. Yeah, you look at the fine print, because when you look at the fine print on some of these laws, and I'm not going to name any senator in particular, okay, who might have been in position to influence this, but when you look at the fine print of some of these proposed, bills, what it does is it says, well, we'll give some money to the players on name, image, and likeness, but then for the ones who are supporting the NCAA, the fine print will say, oh, by the way, they can have an antitrust exemption on everything else.
Yeah.
You really need to watch your back pocket.
Unfortunately, we've got hard time breaks. I wish we could go so much farther because there are a bunch more layers. Maybe we can circle back down the line. I really do appreciate, though, you jumping on with us and kind of spelling out what some of this means. It's going to be fascinating to see where it goes moving